Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists, and as uncertified podcast hosts, we try to bring our audience of trial and appellate attorneys some news and perspectives they can use in their practice. As always, we are most appreciative if you would recommend this podcast to a colleague if you find it useful.
And before we jump into this week's discussion, we want to thank Casetext for sponsoring our podcast. Casetext is a legal technology company that has developed AI-backed tools to help lawyers practice more efficiently since 2013. Casetext is relied on by 10,000 firms nationwide, from solo practitioners to Am Law 200 firms and in-house legal departments. In March 2023, Casetext launched CoCounsel, the world's first AI legal assistant. CoCounsel produces results lawyers can rely on for professional use, all while maintaining security and privacy. Listeners of our podcast enjoy a special discount on Casetext basic research at casetext.com/CALP. That's casetext.com/CALP. And as of June 2023, still not generating fake cases.
Not yet. Just give it time. Yeah. All right, Jeff, as you know, on the California Appellate Law podcast, we lean pretty heavily on state appellate court decisions. And so we'd like to try to fill up that lacuna by bringing back onto the show Cory Webster, a Ninth Circuit appellate specialist, and have him fill us in on what we may have been missing over the past months coming out of the Ninth Circuit. Cory is an appellate attorney at Dykema, where he works on appeals, but also serves as embedded appellate counsel on trial teams. Cory is actually where I learned the term embedded appellate counsel and have been using it ever since. Cory's work focuses on both appeals and key trial motions in complex commercial litigation. Cory formerly worked as a Ninth Circuit clerk for Judge Consuelo Callahan and as a clerk in the United States District Court for the Central District of California. In January of 2023, Cory was appointed to the Ninth Circuit Advisory Committee, and many listeners of the podcast will know Cory from his Ninth Circuit updates on LinkedIn, where he provides inside baseball on recent decisions and news coming out of the Ninth Circuit. Welcome back to the show, Cory. Thanks for joining us.
Tim and Jeff, it's great to be back. One minor clarification so I don't get in trouble. It's the Rules Committee that I was appointed to this January. Which is perfect for, appellate nerd like me.
Perfect. All right. Thank you, Cory. All right. Well, Jeff was itching to ask you about a recent victory that your team had, Cory, out of the Fourth Circuit, Fourth District Court of Appeal in California. We're going to get to the Ninth Circuit stuff, but you had a recent interesting published decision out of the California Court of Appeal in Perry versus Kia Motors. Jeff, you want to ask Cory a little bit about that decision? That was a decision, the holding related to 998 offers, and held that in the face of consumer protection laws, 998 still applied. So it was an important decision for practitioners to be aware of.
Yeah, sure. I had some questions. You won't go too deep in the weeds because I know it's still an active case, but I noticed, Cory, that you were embedded counsel in this case, embedded appellate counsel, and this was a trial that was conducted during COVID, and where the jury deliberated during COVID was a big issue. Courtroom procedures was a big issue. And I just was wondering what the experience was like being embedded counsel in a courtroom during COVID.
It was a really interesting experience. It was definitely the first of its kind for me. At the time, Orange County Superior Court was in partial reopen mode, where of all the various departments, the several dozens departments in the civil court, only five courtrooms were open for trials. And so pretty much all cases were kind of waiting in the logjam to be in there when our case got its turn. We're in the complex court. Our case was not a complex case, but that's one of the courts that were open. Pretty large room, could make for, the jury did not occupy only the jury seats. There was a handful of them in the jury seats, but to allow them to be spaced out, there was just a few, and the rest were in the gallery. And the court allowed only attorneys, the parties, and witnesses to be in the courtroom. So, and attorneys were pretty even limited too. So we, as the embedded appellate counsel, were the first ones to kind of get the boot. But the court justified the limited access it provided by broadcasting by live stream. the cases. So as embedded appellate counsel, I had to, I got to sit at my desk comfortably and watch the live stream and communicate with the trial team live by text messaging.
Now, Cory, it's been a long time since I've been in the actually been physically in the Orange County Superior Court building. But last I recall, internet access was not provided there. Are you able? Was the trial team able to get internet access, Wi-Fi access using their laptops? Could you communicate with them via laptop, or did it just have to be via phone call during breaks?
We communicated by text message. So whether they actually had internet access, I actually don't know. But I know that in the past, what we have done before is a paralegal who's there helping run the show from a whether tech standpoint or whatever has like a hotspot, and so they usually do have a mobile hotspot to provide internet access. But whether that was there or not, it wasn't. We communicated by text messaging.
Yeah.
All right,
I picked up a tip recently from Ryan McCarl, one of our other former guests on the program, who talked about how he uses Google Docs to give tips to the trial attorney, just opening up a shared Google Doc, and you could type messages back and forth to each other. But that requires having internet access.
I like that.
Yeah. Now,
Cory, congratulations to you and Jimmy for a great result there in Perry. Big victory.
Thank you. It was a big one.
All right. Now, Cory, as I mentioned at the top, you are very active in the Appellate LinkedIn community, where you keep your thumb on the pulse on various controversial topics. I'd like to know what you've found from the comments you've elicited on some of those posts. So, for example, footnotes in appellate briefs. We're going to get we usually do these really controversial topics at the end during the lightning round, but I want to ask you about some of these now. Footnotes in appellate briefs. That can be you can make a lot of friends or a lot of enemies on whether you endorse footnotes in appellate briefs. What is your position? What is the sense of the appellate community on whether footnotes should be embraced or avoided?
I feel like this is a topic where the interesting thing to say and the thing that will get everyone nodding their heads is avoid footnotes. If it needs to be said at all, then it should be said in the body, and that sort of thing. But there's also in favor of footnotes. There's all in favor of avoiding footnotes is the kind of tech angle of acknowledging that judges are reviewing briefs on their tablets, on their iPads, what have you. It can be distracting. It's even harder or more distracting on the eyes. You got to use your finger and not just your eyes to glance up and down from the text to the footnote. Those are valid points and things to consider. But where I come down on this is, I think it's not that realistic to avoid footnotes altogether in briefs. There's too many times where there's something that will legitimately disrupt the flow or give the wrong idea about whether the point you're making is critical to the appeal, and as opposed to a tangential point that you think is going to be a question in the minds of the judges that, oh, by the way, this is how this tangential issue was resolved, footnote to address that. There's so many times when you read through a brief, and if you put on the lens of a judge or a law clerk looking at it, you come up with questions that you're going to have as you're going through it. And sometimes the answer to those questions really is irrelevant to the disposition of the appeal, but maybe a hang-up that's going to be that lingering thing in the back of the judge's mind. And I think that calls out to me for a footnote. And I think, of course, you should not overdo footnotes, and many lawyers do overdo footnotes.
Yeah. But
this hardline stance, I don't know. I'm not in favor of.
Yeah, that recalls to mind Chief Justice Roberts' advice on footnotes. As I recall, it was if it's not a relevant point, drop it in a footnote, and then in a later draft, you can just delete all the footnotes.
Yeah, he learned that from the Supreme Court justice who he clerked for, editing his work, where he was given basically 2 rounds of edits. The first one said move to footnote, and then the second round of edit was delete the footnote.
Yeah. And then to your point about the head bobbing up and down, reading the main text, dropping down the footnote, back up to the main text. Where was I? What was the writer talking about? That reminded me of Samuel Johnson's. He actually weighed in on the topic of footnotes. The 18th century public intellectual. The mind is refrigerated by interruption. The thoughts are diverted from the principal subject. The reader is weary. He suspects not why, and at last throws away the book which he too diligently studied. Sometimes that's the impression I get from too many footnotes. If it's just a couple here and there, or if it's a topic that, well, I wasn't quite sure, I was persuaded I need a little something more, maybe that's in the footnote. You ever tried I don't want to linger too long on the subject of footnotes, but you ever tried, what about the alternative of replacing a footnote with parentheticals?
There's sometimes that can work, but quite often the point you're making is a tangential point that I don't think the parenthetical helps you with that. I think it's actually more distracting. So I think you should look for ways in which that might make sense, because there's sometimes maybe a footnote is being used in a way that a parenthetical might be a better alternative. But I think that's the minority of the times. Okay,
another brief writing prompt that you put out to the LinkedIn community was a question that Jeff is going to weigh in very heavily. 2 spaces or 1 after a sentence, and you note that the orthodox rule is 1 space, obviously, but there are some traditionalists out there, some of the older jurists on the bench, who still look for 2 spaces, and maybe we need to defer to them, or at least know thy reader. What is how do you come down on that? Should it usually be 1 space, but sometimes 2 spaces? How do we approach that thorny issue, Cory?
Okay, so I need to start by saying I am a 1 spacer. 1 space is correct, but to your point about know thy audience, that's the point of my LinkedIn post that you're talking about, is really encouraging your audience to be the one who matters. So even on things that you're like, oh, I know that this is correct, if you know that your audience disagrees with you, why would you do it the way that you think is correct? Now, the problem that we have as lawyers is we don't always, and most of the time, we don't know for certainty about the preference of a particular judge who's going to be deciding my case. But I don't think that means we should just hold up our hands and say, well, okay, then I'm just going to go with all my own preferences because I don't know this. I think the goal of studying and knowing your audience is something that we should never stop doing as lawyers.
That's good advice, and that takes us to our next point, which I think is along the same, imparting the same wisdom about using contractions in briefs. And there's a trend toward informality that would permit using contractions even in legal briefs and opinions. And you mentioned about Justice Kagan, who is a big fan of using contractions, but then you pivot and talk about how Justice Kagan has decided not to use them in certain kinds of opinions. Tell us about that.
Yeah, so this was at the Ninth Circuit Judicial Conference last summer. Justice Kagan came and was, the highlight is her speaking, and it was really fascinating because it was there that I learned that she doesn't use contractions in majority opinions. It is something that had never occurred to me before because I had always associated her with this, very simple conversational style of writing that often you find contractions in her opinions. And what I didn't know until she said it is that she just doesn't do them in a majority. And she explained her reason is that out of respect for being the one who's speaking on behalf of the court, and she is aware of at least one colleague who thinks that contractions shouldn't be in judicial opinions, she doesn't do them in majorities. And the thing, like the last topic we were just talking about, it's kind of the same idea here, is thinking about what is this for? Who's the end user? And thinking about that and letting that sometimes take precedence over your own preferences. I'm someone who I don't think contractions should be in every sentence of a brief, but I think a well-used, well-timed contractions, I like that as a matter of writing style. But sometimes I think our writing styles should kind of take a backseat.
Well, on that point, I have to ask on Jeff's behalf. I don't know if we covered this the last time. What do you make of the citation parenthetical cleaned up? It's in vogue, but what if there is a jurist who's reading your brief who doesn't like it?
So I can't remember if we talked. It might have been brand new or whatever when we talked last. But Tim's going to like what I'm going to say. Jeff's not going to like what I'm going to say. I am all for judges using it. In fact, if more judges use it in decisions, then now when we quote those things, they've already been cleaned up, and it's great, right? I am all for judges doing it. I am not as comfortable doing it, and I have never once done it in a brief, for all the reasons people have given for not doing it, and that Tim has mentioned before, including that I don't know what is being conveyed in the mind of the reader when they see that, no matter what I intend it to mean. I feel like it's something that requires, well, let me go back and check their work, and it's me making more work for that reader. Let me check to make sure they haven't changed anything substantively. And I just the specter of that thought process, I'm good without it.
Yeah, but Cory, if you start with the assumption that a research attorney, a clerk, or even a justice is checking every site anyway. Jack Metzler was on the podcast, and he said, judges assume lawyers are not being honest with their citations. If you start with that presumption that they're checking your citations anyway, and you've used cleaned up perfectly, isn't that a fantastic way to show and build credibility with the court that you've actually cited something correctly and yet presented it in a clean, more readable fashion?
That's maybe one argument, but my response to that would be those law clerks and they are trained, not necessarily, I mean, every judge kind of has a different way of doing this, but one district court judge, when I first started my clerkship, was very clear. Was not a trust but verify, was like a just verify. And I think those who approach with that skeptical lens are not suddenly like, oh, well, I'm no longer skeptical, and I think it's the more likely outcome is, oh, you made me have to like not just check the general gist, is this right? Or have you stated a correct point here? But now let me look at every single word to see if you took what you took out or whatever. I think that type of person who's already coming to it skeptical is not going to no longer be skeptical, and instead of just maybe going to be more likely annoyed that they had that extra work.
All right, the skeptical floor. Got it. All right.
Well, at the time of this recording, our episode with Jack Metzler, the originator of the cleaned up citation parenthetical, has not yet aired. So after that airs, Cory, we'll have to circle back.
We'll see if he's convinced me.
It moved me slightly more toward Jeff's side. I am still with you. I haven't used it. I don't have any plans on using it, but it has softened my view on the use of cleaned up. All right, final topic before we jump into some interesting recent Ninth Circuit decisions over the past few months. We wanted to talk about legal tech. Now, earlier this year, Cory, you moderated a panel, I believe for the Orange County Bar Association, on tech tools for appellate and trial lawyers. Can you give us some of your takeaways from that panel? And that panel, as I recall, featured Ross Guberman.
It did. Ross Guberman, Brief Catch. There was also Jackie Schaefer.
Yeah.
And Nicole Clark from Trellis. And I mean, the kind of goal of that panel was to not necessarily just highlight those three products, but to kind of give a glimpse into three products and kind of spur the thinking of like, there's kind of a world of tools out there that exist and that maybe don't exist now, but will exist in a year or in a couple of years. Just there's a world out there of tools available to help us in the practice of law. And it was for the appellate law section of the Orange County Bar Association. So it was focused on appellate lawyers. But one thing I'll say, I've had Brief Catch for a long time now. And so it wasn't anything new to me there. And Ross is fantastic. But I'll tell you one thing, Clear Brief is, in a word, incredible. And it's one of those things where don't don't learn about it unless you are prepared to get it, because once you know about it, you have to have it, because it's just what it can do is so incredibly cool.
Have you had an opportunity to check out Type Law? Type Law is a product that
No, I haven't. Tell me about it.
It can assemble a brief and do some of the things that Clear Brief does. I thought was kind of cool. But here's what was really the selling point, and I had the same reaction as you. Don't look at it unless you're prepared to get out your credit card right then and there. It will put together your appellant appendix for you. So you ever gone through, we've all gone through the process, and we get toward the end of our brief and we realize, oh, there was one other docket item that we need to include in that appendix, and it happens to be right in the middle. So you go to your paralegal, would you mind tearing apart the appendix that you've done so you can insert this one additional document that I forgot in the middle of it, and renumber everything, redo the indexes? This was created by people who decided, who came up with the idea while doing appellate appendices, and thought, this is the 21st century. Why are we still doing this manually? And so it's all done electronically. You can just add in another document at the last stage, and it will renumber everything on the fly, redo your indices, no trouble at all. So it's a really cool product.
Oh yeah, that sounds really cool.
Yeah. All right. Well, let's get right into the meat then and talk about some notable Ninth Circuit cases coming out in recent months. First one, we'll start from the most recent, from June 2023. This is the Jack Daniels Properties versus VIP Products case. This case deals with the interesting question of what do you do when binding precedent squarely forecloses your position. And back on episode 9 is when you were with us last, Cory, and we went through a lot of the major differences between Ninth Circuit appellate practice and California state appellate practice. And one of the big differences, perhaps the big difference, is that in California there's no horizontal stare decisis. So if you got a previous opinion, a decision that goes squarely against you, as long as you've got some other decision that allows for your position, then you're clear sailing. You can ask for that result. But not so in the Ninth Circuit. If there's binding precedent, then sorry, you're hosed. And that's what the appellants were up against in the Jack Daniels case, and yet they somehow managed to win anyway. So tell us how they did that, Cory.
Yeah, so in the Jack Daniels case, some of the listeners, I think, this will be familiar to them because it's gotten a lot of press from the Supreme Court decision that just came out on this case. And it's a trademark case, trademark infringement case, where you had a toy company that came up with a toy that looked like the Jack Daniels whiskey bottle, and Jack Daniels wasn't pleased. Well, Ninth Circuit, the problem that they faced is Ninth Circuit precedent basically established a test that meant Jack Daniels had to lose, and the issue is, okay, well, what do you do if you're in that position, and you're in the court, you're in the lower courts, and you're working your way up? Do you try to distinguish the case? Do you say that it's bad law? No, don't say that it's bad law. It's binding until you have established that it's bad law. So don't do that. And of course, if you have an argument for something being a case actually being distinguishable, you of course should make that argument. That should be your number one. But the Jack Daniels counsel here wisely recognized that precedent did actually foreclose, and there was a law of the case issue too, because there had been a prior appeal. So they were really stuck with how the case had been framed. And so what did they do on their appeal? Why waste the time of doing a full merits brief, a reply, maybe having oral argument? They right away filed a motion for summary affirmance. That's right.
These are the appellants.
To the appellate court, they said, please give us a quick loss.
Yeah. These are the appellants asking the court to affirm.
Yep. And do so summarily, please, without needing full briefing or argument. And the briefing was pretty short on the motion for summary affirmance, where they could just say, we recognize that there's precedent and law of the case that squarely forecloses this. To allow for an efficient way for the court and for the parties to litigate this issue, whether it be on banc or with the Supreme Court, please summarily affirm.
At that point, Cory, do you know, had Jack Daniels attorneys had they preserved their arguments? What would they argue if not for this binding Ninth Circuit precedent standing in their way? Did they have to raise that, put that on the record somewhere before they asked for summary affirmance?
Well, I'm sure they did in the previous to the first appeal, because I think once they had the first appeal that set what was going to be the law in that case, at that point, I'm assuming that the trial court proceedings were pretty limited. I mean, they maybe have done some discovery and things like that, but yeah, I would think it's pretty straightforward from there, where it's like, can you just, punch our ticket here and let us move on to the next stage?
Yeah. So what happened at that point? So they're staring down the face of binding precedent that says that they lose. They strategically file their motion for summary affirmance right out of the gates of the appeal, and the Ninth Circuit does what?
The Ninth Circuit grants that in a pretty, form order that just says granted and cites a rule that allows for a summary disposition. I think it was a 2-sentence order, and from that point, from a panel's stage perspective, the case is over and they can petition for rehearing en banc.
And that's what they did?
I believe they did that, but I don't think they got any votes. Well, they didn't get a call for a vote. So no one took it up on the Ninth Circuit to rehear there. And so they moved to the Supreme Court.
And the Supreme Court granted cert.
Not only did the Supreme Court grant cert, but the Supreme Court sided with them in a unanimous decision.
So Cory, retroactively, it's easy to say, oh yeah, save money, you save time. It's much more efficient just to seek a summary affirmance. But on the other hand, the odds of getting the Supreme Court to grant cert, and then the odds of getting reversal once you're in the Supreme Court, statistically speaking, isn't the better, stronger play always in the Ninth Circuit to try to do a brief on the merits to see if you could turn the judges around on either distinguishing the cases or evolving the law?
I think it's almost always going to be the case that you're going to have some argument that gives you, whether it be a distinction, or whether it be you have some other issue that, well, even if we lose on that issue that's foreclosed, we have another one that saves us, another issue that if you agree with us on this other open question, that it makes this other first issue that we're going to lose on go away. There's any number of things that can allow for you to have an argument where you need to go to the merits. And it's definitely not a common thing that came up in this case.
Yeah.
But I will say, we say sitting back, well, it's easy to say this was the right call. Well, they made this call at the, they were the ones that needed to make the call, and they did it. And
yeah.
And I'll tell you what, the lawyers, they have a really good team. Whether they made this decision or not, you look up the names there, and it's all-star names. Lisa Blatt, who's in the Supreme Court several times every year, they're making this call. So it's a bold move.
Yeah,
it's definitely a bold move. But do you know what's a worse bold move? To say things like, please overturn this decision in your merits brief. When the panel can't do that.
Yeah. No, that's right. And to that point about if you're going to make a bold move like that, you're going to want to make sure that you have had competent appellate counsel on your team the entire time. Because I think we all know sometimes we get calls that we're in trouble now. We need to bring appellate counsel in now, and you're looking at the record and it's a mess. There's all the arguments that needed to have been made have not been made. If that had happened here, this strategy, which is already pretty daring, would have probably been foreclosed, or probably wouldn't have been a sufficient record to go after this bold strategy.
Yeah, it's hard to say. I think doubtful that cert would have been granted if there was some procedural problem along the way, born out of not making sure they dotted all their I's and crossed all their T's.
Right. Okay. So that's the Jack Daniels versus VIP Products case. Let's turn now to the next case. This is another big en banc decision that came out just this month, June 2023. This is the Gap versus Fisher case. Cory, would you tell us about this case? This involves the shareholders of the Gap that sued the gap in California federal court concerning some securities violation, and it wound up with an en banc vote. Tell us a little bit about this case and the importance of it.
Yeah, so the thing I want to share about this, and you summarized enough of the facts of what the case is about to make the point, or to take the lesson from this, that I think is a really fascinating thing about the Ninth Circuit and how en banc works in the Ninth Circuit. And that is that in this case, the 3-judge panel sided with the defendants, meaning that the case was dismissed. The shareholders' case was dismissed, and that's coming up on appeal. The plaintiffs are appealing. The 3-judge panel affirms, siding with the defendants, the gap. By the way, is it the gap? I always knew it as the gap, but the decision just says gap. So what is that? I don't know what that is.
That's right. I don't know. Yeah, the part of its marketing that's stuck in my head makes me think it's the Gap, but now that I picture the store, it's just the 3 letters Gap. So I don't know.
So anyway, the plaintiffs lost with the 3-judge panel, and then a petition for rehearing en banc is filed. And the issue here presented a case that quite often lines up. I think it's not surprising that the case kind of lined up along the lines of party appointments.
I see.
It was a kind of a politically charged, not in the sense of what the case being about politically, but more judicially politically charged, of philosophies about cases like this that should go forward or shouldn't.
Yeah, so this is about a forum selection clause. So was there like a textualist versus a purposive type of gloss?
Well, it was not textualist versus purposivist. That was definitely in the background here, but you also had this added layer of, you had a statute, and the question is whether the provision, the forum selection clause, was conflicting with the statute. There's definitely the atmospherics of, I can't even say the word.
Yeah.
Versus textualism.
Yeah.
But it kind of in a wonky way, because you had the text of the agreement and the text of the statute too. But I don't know that votes lined it up perfectly, along ideological lines.
I wasn't aware. Is there an R versus D or liberal versus conservative jurisprudential question on contracts over statutes? Wasn't aware of a dividing line.
Definitely not as worded as broadly as that. But I think when you get into securities laws and what they're meant to get at, and the securities laws have specific provisions that don't exist as to all other types of subject matter. And I think where you can see R and D come in there is, and I think this is painting in maybe too broad a brush, but I think the generalist point applies here. And that is, let parties to a contract have what they contracted for. More often, you're going to have a Republican-appointed judge who kind of agrees with that way of looking at a case.
Oh, got it. Okay.
And the D is more a matter of like, well, hold on, not when this law that's meant to protect consumers is saying otherwise.
That sounds more familiar then. Yeah, the right of contract versus the general protection of consumer protection statutes. If you read those too broadly, then it interferes with the right of contract. Yeah, I could see that breaking down on ideological lines, jurisprudential philosophy lines.
And the thing of getting back to the en banc point here is, if you look at the rule for when en banc is granted, what you won't see is when judges disagree with the decision. It's the kind of things that sound similar to getting cert granted. It's where it's an important issue that will have ramifications on a lot of cases, or where it creates a split with other circuits. But I will tell you, in practice, quite often, how a judge thinks about whether the 3-judge panel decision was right or wrong weighs pretty heavily in terms of deciding how to vote on a call for rehearing en banc. And I think that's to be expected when you know that 3-judge panels can set precedent for the whole court. I think it gives every member of the court some stake in how these decisions are coming out. And so anyway, this does come into play. And what I kind of suspect happened in this case is you've got a court with pretty evenly split in terms of the party affiliation of who appointed them. You have 16 Democratic appointed members, although as of a couple weeks ago, maybe we could say 15 because we have a seat to be filled, and 13 appointed by Republican presidents. And you need a bare majority of that 29 to take a case en banc. But when it gets interesting is then after that, en banc is meant to be the full court, but 29 is just way too cumbersome, and that's not what the way the Ninth Circuit does it. It is not a full court; it's a mini full court. I'm sorry, a mini en banc that's 11 judges, and those 11 are drawn from the 29, and so there's no guarantee. If you have a vote that's 15 to 14, and by the slimmest of margins goes en banc, well, what if 10 of the 14 who voted against rehearing en banc are the ones on the panel?
That's right. And as you mentioned here on the 11 judge panel here, 5 were Trump appointee judges.
That's right. And then you had another, not Trump, but another Republican appointed one. And surprise, surprise, the decision came out same way that the 3-judge panel did, 6-5, and there you have it. There's this almost like this. I wonder whether since Trump appointed as many judges as he did, the numbers have balanced out quite a bit. It was much more heavily skewed Democratic appointed with the makeup of the active judges on the court, and now with it being much closer, you can have this kind of thing happen where I'm not going to say maybe buyer's remorse is too sharp of a point here, but someone who's like, I think this 3-judge panel was wrong, we should vote to rehear it, and then you get an en banc decision that basically says what the 3-judge panel did, because you don't know the makeup of the judges on that en banc panel.
Makes it much less predictable what the Ninth Circuit is going to do on an en banc petition.
It certainly does.
Yeah. All right. Well, that seems to be the takeaway there. That's we talked about that there is an aspect of difference in judicial philosophy. It's not a terribly stark difference, but it was enough to matter. And the recent recomposition or balancing, adding more our appointed judges over the last term or the prior term under the Trump years has changed the makeup of the courts significantly. That makes these en banc petitions a different calculus than they may have been beforehand.
Yeah, and you really want to see, okay, if your case went en banc, the day that you find out who are those 11 judges is a very revealing day.
Now let's talk about Slack Tex versus Pirani. This is another June 2023 case out of the Ninth Circuit. This is where a visiting judge on the panel wrote a dissent and wound up being vindicated by the Supreme Court. So this is the upshot of the Slack Tex Technologies case is that when that one trial court judge sitting by designation can be the deciding vote that sets binding precedent in the circuit. And the reason that the court goes to the Supreme Court. Cory, tell us a little bit of the backstory in Slack Technologies and how a visiting judge wound up setting Ninth Circuit precedent.
Yeah, so this is something that's always fascinated me. This idea that, I'm not, by no means am I criticizing this dynamic that I'm talking about here, but that just super fascinating to me that a visiting judge, quite often is a trial court judge from a federal district court anywhere in the country, comes and sits by designation on the Court of Appeals in the Ninth Circuit. And very often, these three-judge panels resolve a case in a divided fashion, 2-1. And quite often, you can have, when you have a three-judge panel with one is a visiting judge from a trial court somewhere in Tennessee or whatever, they cast the deciding vote. And that's kind of interesting. But when you know that the deciding vote setting precedent for the circuit, that becomes, I think, even more interesting. Again, I don't think that that's problematic in any way, but I find it incredibly fascinating. And this happens on a pretty regular basis. There isn't, I don't think, a month that goes by that you can pinpoint this happening in a published decision in the Ninth Circuit where the deciding vote was from a visiting judge. And
okay, so it wasn't a dissenting vote. I misspoke earlier, but this judge was the deciding vote in the majority.
Yeah, so the visiting judge was the deciding vote, and the two-judge majority the set a precedent that created a circuit split. So all circuits to have addressed the issue that was presented in the case had all come out one way, and in a divided decision, 2-1. With the visiting judge casting the deciding vote, as I said, they create the circuit split. Well, it was Judge Miller, who is a Ninth Circuit judge, who wrote a dissent, basically saying we should have joined, all of our sister circuits and how we resolve this case. And what's interesting, so the Supreme Court took the case, and when you consider the criteria for when the Supreme Court takes cases, circuit split is, like the top of the list in terms of like what's going to get the Supreme Court's attention. And I'd venture to guess that if the vote had gone the other way, if the visiting judge had voted with Judge Miller and Judge Miller's decision was the majority, you'd have a handful of circuits who would address the issue, all of which that came down one way. That doesn't look like the kind of thing that the Supreme Court is taking these days, especially as their docket gets smaller each year. So anyway, this caught my eye as just sort of one of these fascinating things where the vote of from one way of looking at it anyway, the vote of this one visiting judge kind of set this on a stage for getting to the Supreme Court, when otherwise I think it was really unlikely that it would have been made it to the Supreme Court.
Yeah, very interesting. So there was all the circuits had agreed, and there was it's curious that the Ninth Circuit decided to go a different way. I mean, even though it relied on the vote of a visiting judge, and I take it was there any call for en banc, or was there? Do you know if there was a petition for en banc review before the parties took this up?
I don't recall specifically. I'd be shocked if there was not a petition filed, but I don't recall there have been a vote called for on this one or not. Yeah. I do know one random kind of tidbit here is Judge Miller, who was the dissenting judge here. He's a judge who I suspect you can count on one hand the number of times that he has voted for a rehearing en banc, and you might be able to count them on no hands. I don't know. He's someone who's very much. I'm not going to tell you that he would never vote for a rehearing en banc. That's definitely not true. But he's a tough vote to get, even if he thinks a case is wrong. He's even written a statement that was submitted in connection with a denial of rehearing en banc, where he said, whatever we think about the decision being right or wrong, it doesn't meet the criteria of the rule. Rehearing en banc is not appropriate. I think he's very much of the camp that thinks rehearing en banc should be granted in very, very, very limited circumstances.
Yeah. All right, so watch out for visiting judges. They can turn the tide. Even in this case was just involving whether a plaintiff has standing to sue under a federal securities law. And again, all the other circuits that had decided the question went one way, and a visiting judge joined the majority to create a majority opinion that went the other way, that set up petition for cert and unanimous reversal by Supreme Court, that brings the precedent of the Ninth Circuit in line with all of the other circuits. And as Cory mentioned, very well might not have been the case if not for the participation and vote of the visiting judge here. So visiting judges can play a very important and often unexpected role in Ninth Circuit decisions. All right, let's move to the next case that you've written up, posted on your Appellate LinkedIn page. The prompt here is: what happens when a member of your panel leaves the court after a decision but before finality? This is the Kelsey versus Garrett case from May of 2023. Why don't you set this one up for us, Cory? What was the Kelsey versus Garrett case about?
So this case was a habeas case. So you've got an inmate who has challenged their conviction through a habeas proceeding. And what happens here is the petitioner wins in the appeal, which is, that alone is notable. Getting habeas relief is a real challenge. And the petitioner here gets habeas relief, but it's a 2-1 decision. Now that's important because one of the judges in the majority is Judge Paul Watford, who is now currently in private practice.
That's right, yeah.
His last day on the Ninth Circuit was May 31st. This opinion was filed May 24th. And by the way, that was a known date. It was known that was going to be his last date, May 31st. So if you are the Attorney General for Nevada, this case came out of Nevada, and you get this decision, and a week after this decision's filed, you now have 2 members on the panel. One voted for you and one voted against you. Sounds like a deadlock to me.
Yeah.
And your case isn't quite over yet. You still have time to petition for rehearing, whether it be panel rehearing or rehearing en banc. And how is that vote going to go? How does a 2-judge vote go when they each are on different sides here? And this presents an interesting kind of situation, right?
Yeah.
And
but as you mentioned before, if it was Judge Miller, would Judge Miller, even if Judge Miller was in the dissent, and now that one of the colleagues in the majority had now retired, would Judge Miller just say, well, that's the way the chips fell, and we're not going to use this opportunistically to change the result?
I doubt it, because what you see almost uniformly, I can't think of in my head a time where I remember this not happening, is that for a petition for panel rehearing, which is different than rehearing en banc, right. For a petition for panel rehearing, a dissenting judge, I don't recall ever seeing a dissenting judge not voting in favor of a petition for panel rehearing. No. Because you're you're saying, yeah, we should do what I said we should do. We should rehear it and rule in the way that my dissent says. And so here you have, if they file a petition, if the Nevada AG files a petition for panel rehearing, there's going to be a deadlock vote. And the fact of filing that petition will, for all intents and purposes, necessitate the drawing of a new judge. A new judge will have to be drawn to replace Judge Watford. I'm guessing that's happened by now. Mm-hmm. I don't know that that's been publicly disclosed on the docket or anything, but I suspect that that's happened. And now all of a sudden, that new judge to the case will be the deciding vote on a petition for panel rehearing.
Okay, so once the petition for panel rehearing is filed, and you don't have all the constituent members of the 3-judge panel still there on the bench, then the Ninth Circuit is obliged to fill that gap in the panel.
With one caveat, it's not simply that they have someone off. It's that if this was Judge Graber, who was in the dissent, if she was the one who left the court, the 2-judge majority can, by a majority as just the 2 of them, deny the petition for panel rehearing.
Okay.
So it's only if you need a third to actually resolve it.
You still need the majority to deny the petition for rehearing.
Yeah. So it's not just simply that you lose the judge that the court is obliged to replace someone. It's this situation where you're going to have a deadlock.
Got it. Well, that's interesting. So that's another thing to watch. Whenever you see news that a Ninth Circuit judge has retired, take a look and see if that judge has participated on the panel of any split decisions, because then you may see another instance of what we see here in the Kelsey versus Garrett case. And so at this time, Cory, this was only not even a month ago. This is just about 3 weeks ago that this happened. So the state of play right now, I believe you said, is that we're still waiting to see what the Ninth Circuit does to replace that replace Judge Watford on the panel.
Yeah,
is that right?
I'm assuming that the state. I mean, I'd be shocked if the state didn't file a petition for panel rehearing, at least, if not rehearing en banc, and that would trigger. Yeah, that assignment has almost certainly been made, whether it's been made public or not. Another time that this has come up is in recent years is when Judge Reinhardt passed away unexpectedly. This happened, and it's going to potentially come up anytime the judge leaves the court, whether it's retirement or otherwise. And there was a number of cases where he was in a 2-1 majority on opinions that were not cases that were not yet final, and so the court, had to draw a replacement. And I remember at least one instance where a 3-judge panel flipped, 2-1 decision flipped as a result of this kind of situation coming up.
Yeah,
fascinating stuff, I think.
Yeah, well, that is fascinating. Whenever you see retirements or other unexpected exits from the bench in the Ninth Circuit, look out for these kinds of situations. Okay, let's go on to our next case. This is going to be, I think, our last case that we'll be able to cover in the time allotted for today. This is the National Pork Producers Council versus Ross. I like to think of this as the case that saved the McRib. This case dealt with the dormant commerce clause, that clause that a lot of us attorneys have probably never touched since law school. It's just exists there in doctrine, but it was a reality in the Supreme Court decision in National Pork Producers, which rejected the challenge to the much maligned dormant commerce clause doctrine. Cory, set this one up for us. Tell us what happened in the National Pork Producers case.
Yeah, so first of all, I'll say I am sure that there are lawyers out there who have, like dormant commerce clause is their thing, but I've never met one. like you said, I mean, I don't think I've even talked about dormant commerce clause since law school. I mean, I thought about it maybe a time or two, but this
something
is
that always it's always there in the issue spotting. Just throw it out there. It probably applies somehow.
Exactly. And this got a lot of press. I mean, it's about California law that significantly restricts the way that pork is processed, and it basically has effects for like the nation's pork production.
Yeah, because I don't think we produce a whole heck of a lot of pork here in California.
Apparently, we do some. I mean, we're a big state, so we don't produce the bulk of the country's pork for sure, but I think we consume our California population share.
Okay.
But the way that the industry works, this basically has the effect of being a statute that applies outside of California.
Yeah, anyone who wants to sell pork in California is going to have to comply with the California statute on regulating the production of pork.
Yeah, so no surprise, at least as the issue spotting thing, like you said, that like this was like, hey, this is a problem, says the National Pork Producers Council. And the Ninth Circuit angle on this that I think is pretty fascinating is the decision from the Ninth Circuit, because it came up through the Ninth Circuit, rejected the challenge here, and rightly so. I mean, it was pretty straightforward decision because under existing precedent, the type of challenge here does not give rise to a claim under the Dormant Commerce Clause. And what the plaintiffs were hoping for here is setting up a case that could, I don't know if you expand or restrict or how you say, that could create a claim for them by maybe putting the Dormant Commerce Clause in a closet somewhere. So, you didn't have much of an audience here. I think that they at least had an argument, getting back to our point about, do you ask the Ninth Circuit to summarily affirm? This was not one of those cases. They made their arguments and such, but I think it was not a super difficult decision here. And Judge Ikuda wrote the majority opinion, or the unanimous opinion for the panel here. But what she says makes me think that she did so somewhat reluctantly, or somewhat maybe predicting that although current precedent rejects the plaintiff's claims, maybe that's not for so long. I've got her decision here in front of me. I'm going to read a part of that. This is the conclusion paragraph. While the Dormant Commerce Clause is not yet a dead letter, it is moving in that direction. Indeed, some justices have criticized Dormant Commerce Clause jurisprudence as being unmoored from any constitutional text and resulting in policy-laden judgments that courts are ill-equipped and arguably unauthorized to make. And she quotes a dissenting opinion from Justice Clarence Thomas there. The very end line, she talks about how the plaintiffs have not stated a claim for violation of the Dormant Commerce Clause under our existing precedent. The fact that she kind of keeps repeating that, this tells me this is someone who thinks, okay, it's pretty clear under our existing precedent, but I'm not so sure that precedent's going to last. And what's really sort of interesting here is that, so the Supreme Court affirms, meaning Dormant Commerce Clause is here to stay. And the fascinating thing I found here is that the Supreme Court affirmed on the slimmest of margins, 5-4, and Justice Thomas was a vote in the majority, a vote for affirming this decision. Pretty interesting, because I think that he was probably the last person Judge Ikuda saw as affirming her decision. And I think by citing him, I think in her conclusion, I think she was kind of thinking there's at least one vote there that would actually maybe overturn precedent here, but not so.
Jeff, you had a comment about this case, didn't you?
Well, I'll just say, look, I looked at this case more as a states' rights issue. Look at it just as a states' rights issue, and not beyond the animal rights issue. I'm not surprised by this outcome or how Justice Thomas voted. It was interesting to see. It'll be interesting to see what other states do and pick up on if they feel empowered to do more and fear the Dormant Commerce Clause less as a result of this decision.
Yeah, it was very much the foreground here, not just the background on this whole argument was what will other states do, or what can other states do, and thinking through the lens of what does a ruling here mean for other cases. Supreme Court's always looking like that, but this case especially so. It was like, that's pretty much what this case was all about, was, well, what is everything that a state can do in this kind of way that's going to have an effect beyond its borders? It will be very interesting. I agree with you, Jeff, to see.
Well, what if California wanted to pass a law that said we're only going to allow guns to be sold in California if the manufacturer has insurance and safety and all sorts of things that make it basically commercially unreasonable to manufacture assault rifles. I wonder if that kind of application of this law would survive a dormant commerce clause analysis.
Yeah, it would be interesting to see. I wonder if dormant commerce clause in that situation might get relegated to the back burner in favor of the Bruin analysis that now it would, it's a Second Amendment case. Okay, dormant commerce clause, that's kind of scarier and weirder and more archaic. Maybe we can resolve it on a separate ground. But I think your intuition is right there to like all sorts of things you can imagine. And and frankly, because of the kind of public comment and what's on our mind right now, especially after the last term of the Supreme Court, I think a lot of people were thinking during this argument about laws about abortion or abortion tangent that are state specific, but that are like you can't go out of state to do this or that, or all sorts of things that couldn't help but think of when this decision was made.
One thing this case reminded me of was all of the auto emissions standards that California has that tend to that indirectly or directly, however you look at it, compels, influences automakers to comply with California standards. And because it's too hard to make different cars for different states, they just make all cars comply with California standards, and then it has this kind of trickle down, almost like a national effect. So California is such a large market for autos and other products that by heightening the standards, it de facto becomes a national standard. So I wonder if I'm assuming that was the gist of the Dormant Commerce Clause angle here that the national pork producers argued, but obviously it was not successful.
Yeah, the takeaway I think here, Jeff and Tim, is California is a big state that can wield pretty great power.
Yeah, absolutely. All right. Well, Cory, I picked up another half dozen, at least, different cases that we could have continued on, but we're going to try to keep this conversation to under our normal podcast length limits of about an hour. So, Cory, was there anything else that you want to share today, or do you want to tell our audience where they can find more of your Ninth Circuit updates?
Yeah. So for now, where to find my updates is on LinkedIn. So find me on LinkedIn if you're not connected with me already. I'd love to connect, follow, whatever. But I post every week on just topics related to brief writing or decisions that are important decisions come out, or lessons that you can take from recent decisions, and try to provide things that news you can use, as someone I know once said. So yeah, you can find me on LinkedIn. That's the place that I kind of hang out, I guess.
Yeah, and you're going to find a lot of great inside baseball concerning Ninth Circuit cases that are coming down the pike. You learn to look for things like the cases that we've talked about today, how to predict what might happen on banc review, what happens when a judge retires from the Ninth Circuit, and all sorts of interesting things that you wouldn't even think of if you're not reading Cory Webster's LinkedIn page. But that's going to wrap it up for this episode. Again, we want to thank Casetext for sponsoring the podcast each week. When we include links to the cases we discuss, including the links that we discussed from Cory's repertoire today, we use Casetext's daily updated database of case law, statutes, regulations, codes, and more. Listeners of the podcast enjoy a special discount on Casetext basic research at casetext.com/calp. That's casetext.com/CALP.
Yeah, if you have suggestions for future episodes, please email us at info@calpodcast.com. And in our upcoming episodes, look for tips on how to lay the groundwork for an appeal when preparing for trial.
All right. Thanks again, Cory.
Thanks for having me back, Jeff and Tim. It's been fun.
See you all next time.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.